only on Newsy.
Dramatic testimony this week in two different cases that have captivated the country. First, the trial of the three men accused of killing Ahmaud Arbery, now officially going on. Opening statements and testimony began Friday in South Georgia. Arbery was killed last year while jogging through a Glynn County neighborhood. Travis McMichael, Gregory McMichael, and William Roddy Bryan are all charged with murder. Arbery's mother sobbed seeing the video of her son's death for the first time Friday. The state says the defendants chased Arbery in a pickup truck for 5 minutes because they suspected he was behind recent crimes in the neighborhood.
This case, all three of these defendants did everything they did based on assumptions.
The first witness called to the stand Friday was the police officer who responded to the scene. He testified there was nothing he could do for him by the time he arrived. And in a rare move, Bryan's defense attorney asked to reserve his opening statement until after the prosecution rests. Joining us now to talk more about this case, criminal law specialist and attorney Lou Shapiro. Thank you for joining us. My first question to you is in regards to the jury pool, which has made headlines this week. Do you see this as unfair representation that there are 11 white people on the jury and one black person?
So from an outsider's view, one could say that seems very unfair. But actually under the law, the actual issue becomes for the defendant. Does the defendant have a jury of their peers up there? So for example, if the defendant was black in this case and you had this type of jury pool, mostly white people, that might be more of a legal issue, grounds to challenge it. But because the defendants are white and the jurors are white, we're not going to see a real legal challenge to this issue if it goes up to appeal.
Right, and so now the trial is underway. Can you talk to us a little bit about your thoughts on the prosecution's challenge and the defense's argument in regards to the old citizens arrest law?
Right, so this is a fascinating concept. We don't see it argued usually in court because most people don't even know they can use it. The concept of citizens arrest is that if a crime is perpetrated on somebody else that's not in the presence of the police, you as a citizen can take matters into your own hands until the police get there and basically try to say, I'm going to apprehend this person and step into their shoes. It's typically used as a shield, though, not as a weapon. So if something is done to you and you need the police to get there and they're not there yet, you try to handle it until they get there. But what happened here is the defendants used it as a sword more. They said, we're going to make the citizens arrest, even though nothing happened to us, we're going to take matters into our own hands. And that's where the prosecution is saying they've gone too far using citizens arrest.
So that's just one of many things that I'm sure lots of analysis will come out in coming weeks as we continue through this trial. But stay with us for a moment, Lou. Also going on this week, testimony got underway in the trial of Kyle Rittenhouse. Rittenhouse is charged with 5 felonies related to shooting and killing 2 men and injuring another during protests in Kenosha last year after the police shooting of Jacob Blake. Some of the most compelling testimony so far, perhaps, came on Friday when the state called a former Marine to the stand. The Marine, like Rittenhouse, was also strapped with an AR-15 style rifle and medical equipment that same night. He described the first person shot by Rittenhouse as acting, quote, very belligerently.
What did you think of him?
A babbling idiot.
Did you consider him a threat?
No.
Did you feel that he posed any danger to you or anyone else?
No.
Now, the prosecution also called on that victim's fiance, who gave an emotional testimony. And this all comes after another key witness was called to the stand Thursday, a journalist who took video of Rittenhouse minutes before the shooting. So, Lou, the question is, the prosecution's strategy so far seems to be focusing on how the shooting started. Why is this, or isn't this, the best approach for the case?
It seems to be that the prosecution's witnesses are already crumbling right in front of everybody. I mean, you would expect the prosecutor to put forth the witnesses that show clear evidence that Rosenbaum was a victim here, that he wasn't asking for this, that he wasn't instigating it. But in fact, we're seeing just the opposite. We're hearing witnesses that this was a person who was not on their medication, that they suffered from a mental health condition that might have contributed to the conduct. We're hearing from witnesses that's saying that Rittenhouse was exercising self-defense because Rosenbaum said he was going to kill him. So everything that could be going for the defense right now is going for them, even though we're in the prosecution's case.
Okay, and so moving forward, how do you anticipate the prosecution and the defense to perhaps change, or the defense rather, to change their strategy? Do you expect that they might because of that?
Yes, because the witnesses for the prosecution are sort of leaning in the defense's favor right now, they might actually second guess whether they're going to call their client to the stand. Are they going to have Rittenhouse testify? They said they would in opening statements, but I don't think they expected the evidence to be going in their favor at this point in the trial.
All right, so that's another one we'll be keeping our eyes on. Thank you, Lou, for joining us.
Pleasure to be here. Thank you.